It's from the New York Times. Here's one of the issues we have with government. It's a legal issue. It's a legal doctrine called qualified immunity. Qualified immunity is the idea that government agents are immune from liability unless there's an explicit pre-existing constitutional right that is violated, which is almost never. Almost never. We've seen it a lot in police actions, but it's not limited to police. Qualified immunity is a pox on a free society because it allows bad actors in government to escape liability for anything that they do, including overt violations, like things we understand to be constitutional violations. You're just going, whatever. But what if I told you that there's a compelling argument that qualified immunity, as solidified and reinforced by the Supreme Court, is based on a mistake, and that mistake is the omission of words from the law that qualified immunity is derived from? The statute that was passed by Congress was not fully recorded in the Federal Registry of Laws, and that our entire understanding of qualified immunity comes from a reading that is the opposite of the intent of Congress. Sensible lunacy. If you think qualified immunity being bad is a liberal position, my friend, then you're not a liberal. You're just a retard. Speaking of non-retarded people who can help me through this subject, though, I'd like to welcome to the show my good friend, Good Logic. How's it going, brother? My brain just completely forgot what was going on, but I'm glad to have you on. My whole subject tonight is the government being inept.
Well, Durham report must have inspired you.
Actually, no, that's the last story I saw.
Really?
Yeah.
I spent 2 hours talking about that stuff.
So I started with, what was the first one? Oh, Minnesota raised the minimum wage in Minneapolis and St. Paul to $15 an hour.
Nice.
They were shocked. They were shocked that over the 5 years that followed, that the number of jobs went down, the number of available hours went down, and overall wages decreased.
You know, that's corporate greed right there. That's corporate greed.
That's what that is. Then we just read about a new lawsuit of a school district where a 15-year-old student was forced to read a quote unquote pornographic monologue written by a classmate and edited by the teacher. They were forced to read it in front of their class for a grade. It's not super pornographic. It's just a female, and the person who had to read it was a female, saying they don't love you anymore, Joe. The other character's name was Joe, because of your dick. They don't love dick. They don't love any dicks. They're a fucking lesbian.
Can't tell you how many times I heard that song.
Yeah. Yeah. And so this mom goes to the school board meeting and starts reading the monologue that her daughter was forced to read, and they shut her down because it's too profane.
Right.
Explicit.
Yeah, that's what happens invariably on these things. They can't handle what they're assigning to 14-year-olds. So it's, yeah, that's an inept government right there.
So Carrie Machette, apparently boring. Okay. How's it going? She just dropped a whole bunch. I think she got lagged out in locals and it spammed all of her comments at once. That's great. So yeah, this last story is qualified immunity. There's a big appellate decision that just came out, and the concurring opinion, the judge who researched it found that the actual law passed in 1870 or whatever that created qualified immunity was actually supposed to destroy the concept of qualified immunity. But when they transferred the law to the Federal Register, 16 words were omitted from the transfer. So the law that was passed is not the law that's written down. It's missing 16 words, and those 16 words undermine the concept of qualified immunity entirely.
Get out of here.
That's what that's what a legal scholar says. That's what the judge says. And it's really fucking interesting. And it also kind of makes sense if you understand when this law was passed. This law was passed during Reconstruction. Mm-hmm. And we know that Reconstruction was a retooling of the country, and they were preeminently worried about the treatment of blacks. I know that seems weird to think about in 1870 because we don't think of blacks being treated particularly nice in the late 1800s, early 1900s. But the idea was they're really worried in all of the Reconstruction arguments, amendments, 13th, 14th, and 15th, that the Southern governments would oppress and exploit black people to increase the population, give them more votes in Congress, but not give them any rights. And so we see that actual concern there. And that is when the law was made. And so when you think about it, they were literally restricting state police from abusing the civil rights of this population.
Right. So why would they give them qualified immunity so they can basically beat the tar out of anyone they want to?
Exactly.
And never face any consequences.
So this story blew my fucking mind. Because I think you and I have talked about qualified immunity. Kurt and I have talked about it. All of the legal YouTubers at one point or another will have to wade through qualified immunity and say, this is the system, man. It's not really fair because you can't sue the government when it fucks you over. But here's what it says. So 16 crucial words that went missing from a landmark civil rights law. Real quick, before we do that, a couple super chats here, Rumble Rants. Cians says, one time I had outstanding parole debt. My state revenue department called and I was like, nah, garnish my tax return. The lady said, literally, do you even know who we are? We are the DOR, and hung up, Department of Revenue. Viola Pride 14 says, I need a Joe rant about the CCSD issue since it's my district. Luckily, I homeschooled my boys. That's that school district that I was just talking about with the monologue. Maybe you should read it.
Okay.
Maybe in a minute. Manville P says, dad drunk, mom not smart, public school did good. Most teachers shit, but a few made a big influence. Not that it should be the only option. Well, I'm glad it worked out for you. Here we go. So let's do this story. So this is a qualified immunity story. So in a routine decision in March, a unanimous 3-judge panel of federal appeals court ruled against a Texas inmate who was injured when the ceiling of the hog barn he was working in collapsed. The court predictably said the inmate could not overcome qualified immunity, the much criticized legal shield that protects government officials from suits for constitutional violations. So presumably this guy's working, negligence of a government employee in this hog barn causes his injury is the argument. We don't get to find out if that's true, because even if a government worker, a government employee negligently constructs a building, negligently maintains a building, negligently orders you to go work in a building that you should not work in any other circumstance, you'd be suing the person making you do this. You can't sue the government because they have qualified immunity because it's not a quote unquote explicit constitutional violation that has been previously recognized, which is crazy. The author of the decision, Judge Don R. Willett, then did something unusual. He issued a separate concurring opinion to draw attention to the, quote, game-changing arguments in a recent law review article, one that seemed to demonstrate that the Supreme Court's entire qualified immunity jurisprudence was based on a mistake. Wait, what? Judge Willett wrote, incredulous. In 1871, after the Civil War, Congress enacted a law that allowed suits against state officials for violations of constitutional rights. But the Supreme Court has said that the law, usually called Section 1983, 1983 claim is when you sue a state actor under federal law for a violation of your rights, did not displace immunities protecting officials that existed when the law was enacted. The doctrine of qualified immunity is based on that premise. But the premise is wrong. Alexander A. Reinhardt, a professor at the Benjamin N. Cardozo School of Law, wrote in the article, quote, qualified immunity's flawed foundation, published in the California Law Review. Between 1871, when the law was enacted, and 1874, when a government official produced the first compilation of federal laws, Professor Reinhardt wrote, 16 words of the original law went missing. Those words, Professor Reinhardt wrote, showed that Congress had indeed overridden existing immunities. Judge Willett considered the implications of fighting. What if the Reconstruction Congress had explicitly stated right there in the original statutory text that it was nullifying all common law defenses against Section 1983 actions?
Wow.
Judge Willett asked, that is, what if Congress's literal language unequivocally negated the original interpretive premise for qualified immunity? I mean, this is...
How does anyone know about these 16 words? How did this get unveiled?
I have no idea, but we have the 16 words. He has the text. I mean, maybe he went back to the legislative record. Maybe no one just ever thought to look. The original, I haven't read the law review article because it'll be like 60 pages and make me want to die. And I just saw this story today, so I'm going to I'll do a dig into it. But here we go. The original version of the law, the one that was enacted in 1871, said state officials who subject, quote, any person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunity secured by the Constitution of the United States shall, and then it says right now, be liable to the party injured in any action at lawsuit, inequity, or other proper proceeding for redress. But here's the language that was left out. So anyone who deprives a United States citizen or anyone within the jurisdiction of the United States deprives them of any rights, privileges, or immunities secured by the Constitution shall any such law, statute, ordinance, regulation, custom, or usage of the state to the contrary notwithstanding.
Nice.
Be liable to the party injured. So this basically says that all common law defenses, all statutory defenses then in action, then existing, are gone. They're eliminated.
We don't need just stinking qualified immunity.
Yeah, this is the opposite of qualified immunity. It's the literal opposite premise.
Those last few words there, as far as saying that any customer usage of the state to the contrary, notwithstanding. Notwithstanding is a legal term to basically mean anything that this is the overriding rule.
Yes. Yeah, anything that exists at the time this is passed is gone. So here we go. The words in italics, for reasons lost to history, were omitted from the first compilation of federal laws in 1874, which was prepared by a government official called the Reviser of the Federal Statutes. The reviser's error, whether one of omission or commission, has never been corrected, Judge Willett wrote, because it would take an act of Congress to change the Federal Register. Logic of the Supreme Court's qualified immunity jurisprudence is that Congress would not have displaced existing immunities without saying so. But Professor Reinhardt argued that Congress did say so in so many words. The omitted language confirms that the Reconstruction Congress in 1871 intended to provide a broad remedy for civil rights violations by state officials. Professor Reinhardt said in an interview, noting that the law was enacted soon after the 3 constitutional amendments ratified after the Civil War to outlaw slavery, insist on equal protection, and guard the right to vote. Along with other contemporaneous evidence, including legislative history, it helps to show that Congress meant to fully enforce the Reconstruction Amendments via a powerful new cause of action, Professor Reinhardt said. And that makes perfect fucking sense. I mean, right there. So you create amendments, and then Congress passes a law to give power to the amendments. And I'm pretty sure each of those amendments actually specifically says this amendment will be enforced by laws passed by Congress. Which is weird. That language is not in every amendment, but it is in the 13th, 14th, and 15th.
It could be that those 16 words were omitted because they're very inart, especially the first part of it, are very inartful. It's sort of confusing when you throw that into the context there. Yeah. But it does seem the way you imagine. You know, it's not surprising to see that type of confusing language in 19th century writing, because if you read decisions going back to the 19th century, they're writing on a whole different level than what we see written today.
Yeah, I mean I would want to go back just to hear how people talked. Like, did they talk like they wrote? Because you'd think they would, right? But it's weird to like that people actually spoke like the written word of the late.
You think so?
Of the 19th century.
You think so? You think their S's sounded like F's? You think that's
yeah? I do. I do.
You're so stupid.
But my point in this, so this whole part is that the federal government is inept and opposed to the Constitution. It's so inept that it apparently mistranscribed its own law, then relied on the error and refused to correct it for 160 years, 150 years.
Yeah.
150 years. And it's a premise of one of the most important and far-reaching doctrines of the Supreme Court. Qualified immunity is routinely criticized by the legal profession. It's routinely lamented by plaintiffs who should have a claim against a government agent and just don't.
So,
and yet, every time the Supreme
this
Court
is your moment to shine. Bring an action for declaratory judgment that the statute be officially amended as of record, and that it should be reincorporated as intended by Congress. Right now, imagine Congress like took out a critical not. It's like, you shall, it says you shall not carry a minor across state lines for the purposes of engaging in adult activity, and instead, changed it took out the word not there. That's essentially what this is.
Yeah. You have to do it now. Now you have to take minors across state lines.
It's like, I don't want to. No, you have to. That's essentially what it's saying the exact opposite of what Congress intended. You would think that a declaratory action that would probably befuddle the hell out of the Supreme Court, don't you think?
Well, this case is I think they're considering bringing this specific case to Supreme Court. Now, the problem is typically you don't get to bring a novel argument on appeal, especially on your appeal up to the Supreme Court. However, this is a little bit of a different story.
I would think that this could be like something that could be like a standalone action, as far as just, look, we have a statute that was recorded improperly, and that it's not carrying out the will of Congress, and accordingly, this should, the court should recognize that the statute be amended as passed by Congress. I mean, you would think that there should be some sort of standalone action for declaratory judgment of that nature, wouldn't you think?
You'd think, but does the court have the power to compel Congress to pass a law to fix an error?
It's a matter of maintaining the law. It's a matter of maintaining the law as passed by Congress.
Can you imagine the cluster that there would be? Because all qualified immunity cases.
The counter argument would be, realistically, okay, let's assume that we can fairly reasonably assume that the government would oppose such an action, because they certainly love their qualified immunity, and they would probably say that repeated opportunities for Congress to weigh in and never having knocked out qualified immunity has, on some level, shown their tacit acceptance of the fact that qualified immunity is a valid. Is a valid
right. They could have changed this at any time. That would be the argument. They could have passed a law to amend this any time in the past, and it's never been done.
Yeah.
But it's weird, because I don't know that anyone's ever heard this.
This is wild.
I mean, you'd think that in law school, they would, like, if this was an issue that's been going on for 150 years since this was passed and recorded, right? That they'd be like, look, it's a weird thing with qualified immunity because they didn't want it to be this way. We know that, but it is. Like that, I can guarantee you, my con law professor would have brought that up. And I think
I'm sure he never heard of this. I'm sure he never heard of this.
Right. No one has heard of this, apparently, until this law review article came out. I'm going to see.
The question is what evidence they have to like, how do they really know that this is not some wives' tale?
Let me see if I can find this article. How long is this?
I'll tell you. Boy. I mean, it seems like a very creative thing for someone to come up with such unusual language, especially in the predicate portion of it.
Yeah, here we go. This article raises a legal version of a popular philosophical question about a tree falling in a forest. If a legislature enacts a statute, but no one bothers to read it, does it still have interpretive force? That's the opening line of the conclusion. That's a good line.
Yeah, that's a great line.
the law review article is long, but it's not that long. So I might have to take a peek through it. It's 46 pages in the sort of Supreme Court formatting.
Uh-huh.
So
Which is like
it's
25 pages for real people.
Yeah, it's like 25 pages and half of those are footnotes. So
Right.
I'll have to go through it at some point. But I mean, this is
Hey, drop me a link. If you have the link there, drop me the link. I'll check it out. That's really wild.
Here's I'll send it. I'll text it to you right now.
Cool.
There's the PDF for it. But yeah, I mean, this concept that government can get its own laws wrong and just roll with it to the maximum, like going full force into the opposite direction.
Well, to be fair, they probably just never changed what they had always been doing.
Yeah, right.
I mean, clearly, based on the way that statute was written, is they recognize the qualified immunity is out there, and they were like, let's knock this sucker out. Which is an interesting thing. Like, why would Congress, like, I mean, you would think that government is sort of like a big wall of blue. Like, what would motivate them to actually knock out qualified immunity? I'm surprised they haven't codified qualified immunity.
Yeah, I mean, it's weird that anyone passed something that would not be qualified immunity, to be honest. Like, it's a strange concept. But Reconstruction was a really weird time.
Yeah.
And I think here's the reason. My reasoning for it lies entirely around understanding Reconstruction.
It's another thing also. What you're talking about here with the Reconstruction period is really important, because the North during that period was really trying to punish the South. And yes. You could see that they would have concerns, like grave concerns, that you're right, the South is going to take this out on Black people and basically treat them like slaves. And if you think about it, they could be like unofficially slaves, and yet, like, with qualified immunity in there, no matter what you end up doing to them, you can force them to pretty much do your bidding, and figure that they're too uneducated and too impoverished to actually stop you and stand up for themselves.
And they're not going to have popular support,
right?
People around them. So if you've got police engaging in various acts of taking property and then transferring it to someone else, or negligently handling property when someone's arrested and just losing it, to themselves, any number of things that they could be doing, to this particular population to suppress them and oppress them, that has nothing to do with whether or not they're owned by a private citizen, but the state itself could actually theoretically enforce against them. And in a lot of ways it did. I mean, it still did that. But those amendments were attempted to curtail it. But the other aspect of Reconstruction, ignoring the North versus South part of it, was a recognition of the actual failing of the Articles of Confederation as well. The Articles of Confederation had too weak of a central government to enforce on the states. Clearly, leading up to the Civil War, the central government determined that it was not strong enough to hold the Union together. And Reconstruction is, for a lot of purposes, a complete rethinking of the same framework that we had applied to the federal government, but the 14th Amendment starts applying all of those restrictions through the federal government to the state. So it is a massive taking and aggregating of power in central government through the 14th Amendment at the time of Reconstruction. So now if you say that you have qualified immunity, then what you're doing is telling the federal government not to enforce on states, which is the opposite of the entire trend of Reconstruction. So that's why it's really compelling as a concept in the context of what's going on at the in the federal government at the time of the passage of this law. And that to me is fascinating. And I think it lends to the argument, but I haven't read the paper yet. But even the question is shocking. And again, this is deep legal stuff, guys. Sorry.
Yeah.
But
I come in here for the boring stuff.
It's critically important. That's the problem with it. It's so fucking important, because if qualified immunity is abolished, I mean, everything changes as far as police actions against people. Police brutality doesn't become, you have to show like an egregious level of force being used to combat police brutality, police losing stuff, like just screwing up your evidence, and just, you know what, whoops, we screwed up, good faith, qualified immunity. Nope, that doesn't happen. Like when the evidence locker guy loses that evidence that you're supposed to get, you can sue the evidence guy. Like,
although, frankly, you would expect that the municipalities would cover the police. A lot of people say, like, the argument against abolishing qualified immunity that you'll frequently hear is like, no one's going to want to become a cop if they don't have qualified immunity. The reality is, it would be built into their contracts, and
it's like saying no
police
one
unions would have built into their contracts that any personal liability a cop faces would be picked up by the city.
Right. And in the way, I mean, the way private industry handles it, you'd say no one would want to be a trucker because of the liability that the trucker faces. Well, the trucking company faces the liability as its employer. Qualified immunity is given to these guys in the course of their duties. But when you can't sue them, it means you kind of can't sue anybody. You're left because you can't sue the state. And so if you can't sue the agents of the state because they're immune from the suit, you're left holding the bag. There's nothing you can do. Nobody can help you. But if you can sue agents of the state, they have agent immunity, or well, basically the agent would get indemnification from the principal being the state employment that's done, or the municipal employee or employer would take the principal liability, just like any company does now. But it would give you a path for remedy when there hasn't been for 100 years.
See, it's interesting because, you know, if you get into a car accident with a postal truck, you don't sue the individual. You actually sue the United States,
and they have to give you permission to do so because they have sovereign immunity.
Right. There's actually but there's a statute that's put in effect that enables you to actually go after them for negligence.
Right. And if they didn't have that statute, the United States would have full discretion to just say you cannot sue us.
Right.
But they said, okay, this is like a thing that's going to happen. There's going to be these accidents. And if we just dodge every lawsuit, that's crazy. That's not fair to our people. So they passed a statute that allows you to do it.
Right.
But it's amazing. So yeah. I don't know. I saw this article and I was like, whoa. And now it's been recognized by the Fifth Circuit Court of Appeals in a case that will likely get appealed up. And a novel argument will be presented to the Supreme Court. Whether or not they'll take that argument from this from whether or not they'll take this case and then further allow that argument to come in as a different question. I think they have to. And there's Clarence Thomas does not like qualified immunity.
Right.
He's commented on how it is not the way it should work. This is not the way it should be. So there are opponents of qualified immunity on the bench right now. It's a bipartisan issue.
Yeah, it really is. This is not really more a left or right thing. This is more of like a powers that be versus the rest of us.
Yeah. So this is crazy. I'm very excited about this. I don't know. I'm hoping that it gets some legs because even if some qualified immunity remains, rethinking the way qualified immunity works, because you have to understand that it basically locked in place immunities from 1875. And the way we look at civil rights violations today is vastly different than 1875. It just is. There's no way around it. So I'm curious to see how they remedy that.
And the way you know, by the way, that it's not a left or right issue is here you have Nick all excited about an article in the New York Times. So
yeah, which is very rare. I'm usually mocking it, and here I am like,
wow,
oh,
look at this. Yeah.
This is actually a really good, really interesting article that somehow hit my algorithm. I've been trying to retrain my algorithm, so I'm starting getting legal stories and stuff back into my feed because it's crazy what's been going on. I've been missing a lot of it. So working on that. But yeah, finding this article today, I was like, oh, wow. Legally interesting, legally challenging, probably over the heads of a lot of people. But trust me, I might put together, it'll probably be a pre-recorded video, but like a long form breakdown of how this works and how it could change things. Because it's shockingly important. It's one of the most important things that the Supreme Court could take on right now.